What I want to do in this lesson is talk about the history of land ownership within the processes of England and Wales and the legal system that is of England and Wales. And the reason why this is the case is because in the previous lesson, in our introduction to land law, what we did was introduce the subject as well as look at some of the unique features of land ownership. And one of the specific features that we're going to focus quite a lot of our time on today is this idea that land is not owned by individual people. Land is owned by the crown. It is owned by the monarchy. And in fact, the only kind of interest that you can have in land is either an interest itself or an estate. Now, this is a very interesting and unique feature of land ownership in England and Wales. And so some of these unique features, specifically that unique feature that I've just mentioned, is a result of and comes out of the fact that the history of land ownership in England and Wales is particularly long and particularly complicated. And so as a result of this, we have the settlement of land law as we know it today because of this historical development. And so that's what this lesson is going to be about, the subject of this lesson. We're going to examine the history of land ownership in England and Wales and see how some of these developments have led to the system that we know of today, the system of having estates and interests in land. So we established in the previous lesson that land law is a subset of property law. We've noted this already. It's a very, very special type of property that exists. It's not personal property in the sense of some kind of personal good. It is not intellectual property in the sense of some kind of intellectual idea. It is a type of property which is sometimes described as realty or real property. Now, in reality, the history of land law informs the concepts that we can still accept today, or at least forms some of the broader overarching themes and examinations that we can look at today. Rather than necessarily every single concept that we have today, it informs a lot of some of the most fundamental and foundational principles that we have today. So let's spend some time talking about the various histories and the historical development of land law in England and Wales. Now, the first thing I want to note is the thing that we started this lesson with and the thing that we ended the previous lesson with, which is this idea that we do not own land, we own estates and interests. And by we, I mean the people, unless you are the monarch that is watching this video. I'm talking about individual people. So, historically, land was seen as a gift from God. And this is the important element that we have to think about here, because essentially, just like with lots of other area of law, especially in the very early periods of medieval England, the development of England, the establishment of the Anglo-Saxon period, as well as the development within the Norman conquest and the Angevin Empire, for example, all of these things were very much steeped in the ideas of the natural law and the ideas of religion and specifically Catholicism within and Christianity within England. And so land was seen as some kind of gift from God. And this theological interpretation of land informs the nature of land ownership. And it also informs why it is the case that the monarchy owns land and that we only own estates and interests in said land. Because land is seen as a gift from God, and given the fact that the crown of England, the person who sits on the crown, the person who sits on the throne in England, is considered to have what is known as the divine right of kings. This theological interpretation, which develops around the 1200s, slightly before, gives this, essentially allows for the development of the view and the idea that the crown owns land because land is a gift from God rather than the people. Now, with the development of this understanding of land and the role/relationship that land has with the crown, we see a shift away from the traditional understanding of the crown in England to the more modern interpretation of the crown in England, or at least a newer development in the crown in England, because the monarch went from being the king of the English, the king of the people, to the king of England, the land itself. So less about the subjects who occupy the land and more the king of the land itself. This is how that shift essentially leads to the very slow and gradual development of the monarchy being the owner of land in England and Wales, and that only estates and interests can be owned by all the ordinary folk who want to purchase land. And so, as such, around the 1200s, a little bit before, the concept of land was something that has always had belonged to the crown. Another major development which takes place during this period is this idea of feudalism. And feudalism is incredibly important for our understanding of the development of land law, because following the Norman conquests of England, the system of feudalism would begin to develop. Of course, the Norman conquest of England takes place in 1066, and then from there we see what is essentially the roots of the modern monarchical dynasty that we have today, or at least the monarchical reign, the line of succession that can be traced all the way back to the Norman conquests. So a system of feudalism begins to develop after the Norman conquests, and we can understand why feudalism developed in and of itself, firstly for a number of reasons, but we can also understand why feudalism is important for our understanding of land law development for a number of reasons as well. Because, as already established, one of the things that was developing alongside the development of feudalism is this view that the crown becomes the sole owner of land within England and Wales. And then secondly, one of the things that is important from an economic perspective, why feudalism begins to become embedded within the English system, is that labour is an inefficient task during the Norman conquest and for the vast majority of English history, owing to a lack of industrialisation as well as a lack of coordination at the time. Of course, the Industrial Revolution won't take place until the 1800s, and so as a result of this, we see feudalism begin to take shape. And so feudalism, being this idea that begins to take place, essentially comes about when the king allows people to use and occupy the land in return for the performance of particular services. And this becomes known as the doctrine of tenure, essentially. And so what is interesting is that no actual transfer of land ever takes place. Instead, the service would be performed in return for the crown to allow the enjoyment of that land for the individual who is performing said service for the crown. This is known as tenure. Now, this relationship between the individual who is performing a service in return for the enjoyment of land and the monarch who is allowing the enjoyment of land in return for the benefits of that service is not something that is a relationship which is limited to just that of the person in question and the monarchy. That person in question can then also offer a tenure to somebody else. The person who has received tenure can offer tenure to some other individual, by which they allow them to use their land and enjoy their land in return for particular services. This process of offering tenure and increasingly essentially dividing up land in return for services is something known as subinfeudation. And so a result of this is that a quite vast and complex system of feudalism begins to develop and to take place. Now, skipping over to land ownership today, we know that land is still owned by the crown in modern England and Wales, in the modern legal system of England and Wales, and so one should view one's relationship with land as either one of an estate in land or an interest in land. Unless you are the monarch, unless you're King Charles watching this right now, that is how you should view and understand the nature of land ownership in this country. And so ultimately, with all this being said, we're going to start to move on soon to looking at the specific estates that exist in land. We're going to start with, I believe, registered title or maybe unregistered title. And that focuses specifically on the nature of the freehold estate. We note from the previous lesson that there are broadly two kinds of estates in land, that of the freehold and that of the leasehold. We'll be focusing firstly on the freehold estate for the majority of the first set of lessons, talking, like I said, about registered versus unregistered title systems, and then we will start to look at leases and the leasehold estate before we move on to looking at some of the more subsidiary issues, such as trusts in land, mortgages, easements, and covenants.